We're just giving people a few moments to trickle in, and we will get started in just a moment.
We have folks trickling in. We're going to give it just a few minutes. And Ainsley, this is all yours. I'm going to let you do your magic.
All right. Well, good evening, everyone, and welcome. We are so glad that you're joining us tonight for the Callais Decision, the impact on voting rights in America's multiracial democracy. A few housekeeping notes before we begin. Tonight's webinar includes a chat feature and a Q&A feature. Please feel free to introduce yourself in the chat and tell us where in Ohio you are joining from. If you have questions for the panelists, please place those questions in the Q&A box throughout the event so that we can track them for the discussion portion later this evening. This webinar is being recorded, and follow-up resources will be shared afterwards. So as Laura said, let me introduce myself. My name is Ainsley Johnson Brown, and I am a co-founder of Ohioans Against Extremism. Tonight's discussion centers on one of the most important questions in any democracy, whether every person has equal access to political representation and an equal voice in shaping the future of their communities. Over the past several years, Ohioans have become increasingly engaged in discussions surrounding voting rights, fair districts, election administration, judicial accountability, and democratic participation. At the same time, some of the Supreme Court decisions affecting those issues can feel distant, confusing, and overly technical. So tonight, our goal is to make this understandable and relevant to everyday voters. We'll discuss the Supreme Court's decision in Louisiana versus Calais, why legal experts believe it could potentially reshape voting rights protections nationwide, and what that decision may mean for Ohio moving forward. Most importantly, we want this conversation to leave people feeling empowered, informed, and prepared to stay engaged. Tonight's event is made possible through collaboration amongst a broad coalition of organizations committed to protecting democracy and civic participation, including Red, White, and Blue, Ohioans Against Extremism, American Civil Liberties Union, also known as ACLU, Common Cause, Fair Districts Ohio, Ohio Voter Rights Coalition, Ohio Fair Courts Alliance, Honesty for Ohio Education, League of Women Voters, and All Voting is Local. We are deeply grateful to everyone that has helped organize tonight's event. We are also so honored to be joined by an outstanding panel of experts and advocates. First, we'll have Andrew Walchuk. He is the Policy Director and Counsel for Voting and Fair Representation at Common Cause. We will also be joined by April England Albright, who is the National Legal Director and co-founder of Black Voters Matter. And finally, Lisa Graves, founder and executive director of True North, True North Research, whose work focuses on democracy, constitutional law, and judicial accountability. So first, to ground tonight's conversation, we're going to have a short presentation from Andrew that kind of walks through the basics of the Calais decision, what the court decided, and why this case matters. Andrew will help us establish a shared foundation before we move into the broader panel discussion. So Andrew, without further ado, I'll turn it over to you.
Thank you, Ainsley. Thanks for helping to organize this, and thank you to all of you for taking the time to join us tonight. I am just going to try to set a little bit of the groundwork of what Calais actually meant, and sort of situate it a little bit, though I know my fellow panelists are going to help explain more of how this kind of fits into a broader project of deconstructing the really hard-won victories of the Civil Rights Act, and the Voting Rights Act, and the victories of the civil rights movement. So I'm going to start off by just giving the background of where this case came from, what Justice Alito said in his majority opinion, and what we expect a little bit of the national impact to be before handing it off to my fellow panelists. So if I can have the next slide. So this is Louisiana versus Calais. So the case originates in Louisiana, and it actually dates back to the beginning of this decade when Louisiana first entered its redistricting process after the 2020 census. So after the 2020 census, Louisiana gets 6 seats in the House of Representatives. The population of Louisiana is not majority Black, but it is a third Black. It's a very large proportion of the state. And so to ensure that the population was represented, the Voting Rights Act comes into play. And in 2021, when the legislature drew their map, they only ordered one Black opportunity district. So giving only one district to Black voters to ensure that they're able to elect the candidates of their choosing. And so this was very quickly challenged by voting rights advocates who recognized that this was a really disproportionate and discriminatory map that had been drawn. And so surprisingly, the Fifth Circuit, one of the more, it's not exactly a champion of voting rights in the Fifth Circuit, but the Fifth Circuit even recognized that this map was discriminatory under the Voting Rights Act jurisprudence of the time and ordered Louisiana to draw a new map with 2 districts that would allow Black communities to choose the candidate of their choosing. And so that gave us the map that you see here on this slide, and those couple of districts in the center, those were the new districts that were drawn. And the Louisiana legislature approved this map in January of 2024. So this was a big victory for voting rights advocates, for civil rights advocates, and very quickly was challenged by voting rights opponents. So a group of non-African American voters sued about this map, claiming that the new districts were racially gerrymandered against them in violation of the 14th Amendment's Equal Protection Clause and the 15th Amendment. So if we can go to the next slide. So the Supreme Court actually heard this case twice. So they had oral argument in March of 2025, and then they ordered re-argument, which is something that very, very rarely happens. It often is a signal that the court is grappling with a potential major change to existing law. And they asked for re-argument on one core question about whether or not states could use race in correcting violations of the Voting Rights Act. And this is something that has been a practice of states for decades now, of being able to look at racial data to be able to repair those issues to ensure that they are not diluting the vote of minority communities and ensuring that those communities are able to exercise their vote and choose a candidate of their choosing. So the justice's questioning last fall was not encouraging. Justice Kavanaugh suggested that there were sort of time limits on the VRA. I think going back to what we have so often heard now from this court and a lot of anti-voting, a lot of opponents of voting rights, essentially suggesting that, discrimination is over and that there is a timeline on when you might be able to use the racial data in order to remedy discriminatory maps or discriminatory behaviors by states. And so we knew already that this was discouraging. There were a lot of people in sort of the opponents' camp who were asking the court to just say flat out that any consideration of race whatsoever was a violation of the 14th Amendment's Equal Protection Clause, and essentially invalidating completely Section 2 of the Voting Rights Act. And so if we can go to the next slide. What we actually got was something a little more insidious. So they did not say that racial data could never be used. And Justice Alito wrote the majority opinion for the court, and he suggested, oh, there may be some case in which it could be used to remedy a violation of Section 2, but we're going to update the law around this. And in his quote unquote update of the law, he essentially made it impossible to ever prove that there was a violation of Section 2, to prove that there was any discriminatory impact of the legislature's decisions when they are drawing these maps. And so in doing so, though he claims not to, he essentially closed the courthouse door to communities of color who are seeking protection under the VRA. So you can go to the next slide. A little bit of sort of what it means. And remember, this case is purely in the context of redistricting. The VRA does apply to, it has broader components, but many of those had already been whittled away by the court. And I think some of my fellow panelists will get a little bit more into that. But on this one, sort of what he was saying about redistricting, previously under the precedents of the courts would determine whether a map has the effect of diluting the voting power of voters of color. That was something that Congress had specifically amended the Voting Rights Act to say that they are worried about effects, not necessarily intent, because intent is very hard to prove. But Justice Alito basically rewrote what Congress had done and really limited Congress's ability to legislate in this area, saying that they really needed to show, and courts need to look at, whether the legislature intended to dilute the voting power of voters of color. And I think we all know that showing what someone's intent is incredibly difficult. It's hard enough with one person. It's even harder when you have an entire legislature with a bunch of people saying different things. It has always been a very challenging endeavor for anyone to prove the intent of a legislature in doing something. And so this is a much, much higher bar for anyone trying to bring these claims to meet in order to challenge a map. And then next, it used to be that courts would examine factors like whether voters of color are geographically concentrated or if they've tended to support a particular candidate or party. And again, he sort of rewrote the rules on this and said, because the court has decided that they are not going to examine partisan gerrymandering and that basically states have free rein, as we've seen over the last year, to gerrymander districts for partisan gain and to give their own parties an advantage electorally, because the court has said that that's okay. If states say that's okay, essentially that's enough. They're going to have to meet an incredibly high burden to show that the reason for the districts being drawn the way they were are because of racial discrimination and not just giving partisan advantage. And we know that, especially in a lot of areas of the South, where the VRA has been so essential to protecting communities of color and being able to have the voice in Congress, especially in those areas, partisanship and racial voting really align hand in hand. And so it's really impossible to tease the two out. And so again, he's created this sort of impossible burden for challengers of maps to meet to show that there's been a violation of the VRA. And it used to be that they would look at a history of discrimination against voters of color. Now, history doesn't matter as much. It needs to be very current just proof of discrimination. History is going to be less important for courts who are looking at this, again, creating another sort of impossible barrier. So what we've seen is they've just raised the bar to where no community is really going to be able to avail themselves of the protections of the VRA as it was designed. And it's really going to give free rein to state legislatures to sort of discriminate at will in the drawing of maps moving forward. Next slide, please. An analysis by our friends at Black Voters Matter and by Fair Fight Action found that at least 19 majority minority districts in the House of Representatives may be at risk. And this is the really key thing. The VRA is not, I mean, we hear about Congress, we hear about redistricting right now in Congress, but the VRA applies to redistricting for lower level races too. It applies for state races, it applies for local legislative districts. And we may see nearly 150 majority minority districts in state legislatures at risk in the coming years. Next slide, please. And we've already seen the way that this has really unleashed a flurry of activity. So Florida, literally the day that the decision came down, the Senate in Florida was in the middle of voting on a new map, and they used Calais as the excuse for passing that map. Common Cause has challenged that map in court already, but that map was passed to give Republicans more of an advantage. and tearing apart historically majority minority districts. We've seen new maps already in Alabama and Tennessee. The Supreme Court just came in this weekend to protect a new map in Alabama that the legislature had drawn there. And we're likely to see a new map in Louisiana where the governor stopped an election that was already underway. There were thousands of votes that had already been cast, and the governor stopped the election in order to draw a new map and give another advantage, get rid of those two majority minority districts that we saw that sort of led to the Calais decision. And we know that other states are already quickly moving to join them. We also are seeing that in the next couple of years, states that may not be able to redistrict now are going to be jumping into the fray. We're also going to see a lot of litigation in other states where we will see challengers, perhaps in California, some of these states that wouldn't be moving to redistrict in the same way. We may see litigation challenges saying that some of those maps unconstitutionally used race, that they did not use the sort of framework that Justice Alito put forth in his decision. And then we have the Louisiana election pause, as I mentioned before. So we've already seen this big flurry of activity. We are really pushing for a ban on partisan gerrymandering nationally. But I will go ahead and pass it over to my fellow panelists for more on sort of the impact of this decision and where this decision came from.
Thank you so much, Andrew. That overview was really helpful because these cases they can feel really technical, but the consequences are very real for voters in the communities. So as you said, we're going to spend a moment unpacking what this decision means in practice, especially here in Ohio. April, I'll start with you. Now that we have, that legal foundation, can you help us connect this, to people's everyday lives? Why should ordinary voters in Ohio care about this decision?
So there's a lot to say about this moment. Our organization is, we do work in each of the southern states that are at issue, not just because of this, but, we organize all the time. We say 365 because we have to understand that when you look at these maps and you see colors and, what people should be aware of two things. These maps are colored and they're colored to represent allegedly political parties. But the reality is they represent people. And people, we don't walk out our doors and we don't see red and I'm not wearing blue, right? You may see our ethnicity, you may see our culture, but more importantly, you see these common values that people have, right? And in this country, people are supposed to have a constitutional right to have that value expressed, not just in a ceremonial way where you just go vote, right? Because the idea that some people suggest is that the Constitution only guarantees that you can just go and cast a vote, but not necessarily to have your representation matter or mean anything or actually mature to an actual position in the state or the federal government. You just get to vote, right? And yet we know a reading of the 14th Amendment and its inaction, the development of the Reconstruction time period, and even looking at when when Congress began to amend the Voting Rights Act, the intent was for Black voters in this country to have meaning behind their vote so that they could change their quality of life, the day-to-day things that your question is anchored in, right? Like, why does it matter? And so I'm challenged today, I'm gonna be honest, because I'm an Alabama born, raised person. So this is very personal to me. And, and I just, the question is, do people care? Right? Like, what we see happening. And the Dred Scott decision, which continues to have life in the Supreme Court, and many of your viewers may not even know what that means, but that decision was a pre-Reconstruction case. And why that case still rings significantly is because with the stroke of a pen, the Supreme Court decided that Black men, ergo Black people, had no rights that white people in this country had to respect. So it didn't matter ultimately that there was a 13th, a 14th, and a 15th Amendment, which were those Reconstruction amendments that permitted, the formerly enslaved to have citizenship. It didn't matter that those rights now of equal protection under the law became written, because in effect, right, we saw 100 years after those amendments where Black formerly enslaved folks never saw the light of day and the power of those amendments. And so we find ourselves here with the court writing a decision, as Andrew just outlined, saying that a political interest, a party interest, is more important than the 14th equal protection right of marginalized people. And so what we find ourselves here is remembering that decision of the Dred Scott Court. It doesn't matter if you're marginalized in this country and you have that right for equal protection, because it will be subjugated to the political desires of some folks. So that's why I'm a little heavy, but quickly to answer your question, why it's important to people who live in Ohio is because this is a representative democracy. The people that you elect have control of the purse and what happens in your home, your communities, with your school, with your healthcare, with your groceries, with your gas, with your air that you breathe, right? With the money that you give out. Your representation is in control of that. And right now we see all over the country these erection of data centers. And people are learning very quickly what that impact will have in their communities. And they're fighting back, but they're being largely ignored because the people who are their representatives are beholden to other interests. And so when you think about guardrails around voting, this is why it matters. So that if you are someone living in your community and you want your environment and your society and your resources to go one way or the other, then you need to make sure that the people that are on that ballot that you vote for will go into Congress or your state house or your city council or your county commissioners and make that happen for you. And so when Black folks right now in the South are saying is that when you unilaterally determine that your desire to be in political power is more important than me having equal protection under the law, the ability to control and bring resources into my environment, that's why it's important. I'll end by saying really quickly, some folks say, why does race matter? Why is it relevant? Why does it matter? Well, if it wasn't so important, those red maps are white people. We only talk about race when we're looking at whether or not people of color have representation. But what often gets overlooked is that all those other counties and districts that are drawn, those are white people largely. So who is getting the opportunity to send representation to Congress, and does their interests align with the interests of those minority people in their states? The history of the United States, unfortunately, says no. Because if we could trust that, then why did it take 100 years between the 13th, 14th, and 15th Amendment? Why were states able to go back and redraw their constitutions to act as if the Civil War and subsequent amendments never happened? Why in 1965 did people have to protest and get watered and beat and murdered in order to get what the 15th and 14th Amendment promised. So that is what's in our hearts right now in the South. As you see these maps drawing, it's very reminiscent of that time period. And that's why it's important in this moment.
Thank you. Thank you. I have a quick follow-up. So we're talking about some of the consequences when voting rights, the protections are weakened. We talk about, vote dilution. Can you tell us a little bit about how people can expect that to impact communities on the ground in this upcoming election cycle?
Well, first of all, the whole election process in the South is in a fray. Louisiana canceled their case. Alabama this past week created a trigger bill, which said that if the courts permitted them to adopt former maps, then their election would also stop. But it's not just stopping for all the elections. It's stopping only for those majority minority districts. So that means that people are confused. Do I go vote? Is the election canceled? So real time, these decisions post Calais are causing a frenzy and confusion as to what people are now going to do. They don't know what to do. And so we're having to figure out and address that, because usually, was what Andrew didn't talk about, was that usually when these decisions come close to an election, the Supreme Court and other district courts have used a principle in a case called, the Purcell case, to prevent these, changes to elections from happening. But we see the court has virtually ignored that standard. Although 2 years ago, mind you, when the lower courts were determining that these maps were in fact unconstitutional because they disenfranchised, African Americans in those states, the Supreme Court decided then, no, that principle requires you to use that old map that we know the court has said disenfranchises people. But this year is not even a discussion, right? So real-time impact on the ground is that it's causing the kind of confusion that's could substantially impact the outcomes in the elections when people are trying, to get their voices heard. Now, if you look at the maps that are being proposed in each of these states, they are specifically taking, for example, in Tennessee, because they did the same thing, there was only one district in which minorities could, send a representative to Congress, one. And so they took that community and they divided it up 3 ways. And what they do is, usually in dilution cases, they will either crack or they will pack, right? So they pack in a way to make sure that you only have 1 seat, or they crack to make sure you have no seats. And so that's what happened in these instances. They're taking these districts and dividing them up like a pie, and taking a community that is 90% Black, for example, and they're taking 20% and putting them here. And they're taking 20% and putting them in this district, and 20% and putting them in that district, so that they're now in a majority white district. And so it doesn't matter if they go to the polls and they may have a different candidate they would like to, put into office to represent their values, they could never win. And so that is what's happening real time on the ground in each of these states.
Thank you. Lisa, one thing that, continues to emerge here tonight and nationally is the question of whether our democratic systems are truly representative and accountable. How does the Callais decision fit into that larger conversation?
Well, thank you, Ainsley, for that, and Andrew for your opening presentation. And April, it's an honor to be on this panel with you, with the work you're doing on the ground, really helping with organizing in resistance to this. Because the short answer to your question, Ainsley, is that this makes America even less representative and less coherent as a functioning democracy. This was a deliberate decision, a deliberate edict by the Roberts Court, a court that has been captured by dark money billionaires who wanted to make sure that they had a court that was going to roll back the rights that were secured in the 20th century. This is not conspiracy theory. This is well documented. I documented in my book, Without Precedent, about how there was a deliberate effort to capture the US Supreme Court. And this decision would not have been possible without that capture. The Voting Rights Act is the single most important piece of legislation ever passed in the United States of America. It was designed to secure those rights that were won with the loss of hundreds of thousands of lives in order to secure the freedom to vote and other freedoms to newly freed people who had been enslaved on these agricultural slave, not plantations, but slave prisons. And it took, as April noted, 100 years to effectuate those promises, the promises in the 13th, 14th, and 15th Amendment. And that too was purchased with blood and sweat and tears, with people being murdered in the face of lynchings, in the face of all manner of discrimination. And the arrogance of this Roberts Court to think that they have the right to take away these rights, these unelected judges appointed under a cloud of dark money and scandal on the nation's highest court, to think that their hubris, that they feel empowered and beyond reproach or correction to be able to do this, to nullify the votes of hundreds of legislators in 1965 and 81, 82, 2006, 2007. These judges on the Supreme Court are not acting like judges. They're acting like partisans who are determined to enable and aid their party, the party that appointed them, in a moment in American history where the people are crying out for accountability. That includes Democrats, independents, and some Republicans who recognize how far the United States is off track, how people are suffering under these policies, how much corruption is happening in plain view, how our daily lives are being affected by giveaways to billionaires, while ordinary people are facing higher and higher costs of goods and schools that are being decimated and attacked by this administration. We are in a constitutional crisis. We've been in this crisis since John Roberts issued the invention of immunity from criminal prosecution for Donald Trump, basically pardoning him and paving the way for his return to power. We've been in a crisis, though, really, since John Roberts wrote that decision in the Shelby County case over 10 years ago, where with the stroke of a pen, he wiped away thousands of pages of findings of the necessity of the Voting Rights Act. And then immediately as that decision was issued, state after state in the South, Texas, for example, started right off the bat to try to make it harder for people to vote, in particular, to make it harder for Black Americans to vote. Then you fast forward to the tremendous litigation from Common Cause in the Rucho case, trying to protect fair maps. This court blocked that, but it claimed that there would be protection against racial gerrymandering, not political gerrymandering. Then in 2022, I'm fast forwarding over a couple cases, the court, again, John Roberts handing the pen to Sam Alito in South Carolina. They, in that case, allowed the white legislature of South Carolina to bleach out 20,000 Black voters out of the first district and just claim it was for partisan purposes, and that was the only thing that mattered, when the lower courts found it was a racial gerrymander. That was the precursor for this decision in Calais. And this decision is not just shameful and wrong, this decision is corrupt. John Roberts literally fought a battle against this issue when he was a Reagan revolutionary at the top of the Justice Department in 1981-82. The U.S. Supreme Court, a Republican-dominated court at that time, had issued a ruling in Mobile, Alabama, in which it demanded that the Voting Rights Act only consider intent and not effect. And John Roberts himself spent hundreds of hours trying to block Congress from repairing Section 2 of the Voting Rights Act to restore the intent of the Voting Rights Act that effects matter, because of course effects matter. Of course effects matter. Of course effects can show discrimination. That's where you see the discrimination, in the effects. And he lost. And he knows damn well that he lost. And yet the illegitimacy, the rankness of this court, in my opinion, to have John Roberts sit on this decision, hand the dagger to Sam Alito to issue this ruling that allows the Louisiana white legislature and white governors to wipe out Black representation in Louisiana, just as we saw happen in Tennessee, just as we're seeing happen in Alabama again. And by the way, that Alabama ruling just yesterday, it was issued, the briefs came in by 5 o'clock, both the brief against and for. And that Supreme Court, the Roberts Court, allowed Alabama to undo those maps in less than 39 minutes. I'm going to end this part of my answer on two notes. One, actually three notes quickly. One is Thurgood Marshall, my hero, along with Frederick Douglass, my hero, in that Bolden decision, that Mobile, Alabama decision in 1980-81, Thurgood Marshall wrote that if that decision were allowed to stand, that would render the right to vote meaningless. I'll put the quote in the chat so you can see it. But basically, he's saying we didn't just fight for a right to vote and have that vote be meaningless. We fought for that right to vote to matter. And that's why we cannot allow it to be diluted by these white legislatures, Republican, Democrat, I wouldn't care what party they were, to do this. Second, since 1939, the US Supreme Court has ruled that the Constitution prohibits both sophisticated and simple-minded forms of discrimination. And in that instance, a decision by Felix Frankfurter on grandfather clauses that were used to block people from registering to vote and only apply to Black Americans because if your grandfather, the so-called grandfather clause, had been registered to vote, you didn't have to face a literacy test or a poll tax. The Supreme Court said, no, that's a neutral law, right? It's neutral on its face, but the effect is to deny people the right to vote. And so we know that this Constitution bars sophisticated, not just simple-minded, overtly racist claims. And then finally, when President Lincoln was inaugurated, after that disgusting Dred Scott decision laden with racist nonsense, in his inaugural address, and I'll post this quote too, and I'll paraphrase it, he said that if we allow a Supreme Court to decide the scope of our rights, the people will cease to be their own rulers. And so that's why I'm proud to have co-founded Court Accountability and work on the front line of trying to reform the court. Because if we do not reform this out of control Roberts Court, it will continue to decimate our rights. It will destroy a John Lewis Voting Rights Amendment Act like that, because these men are acting as politicians, determined to aid their side. And in the words of Michael Podhorzer, they are imposing a neo-Confederate agenda on America. And we cannot let it stand.
Talking about the effects of the Roberts Court, it really makes me wonder, what role should courts play in protecting voting rights, both idealistically and as lower courts now have to follow this Callais decision? That's a follow-up for you, Lisa.
Oh, okay. Okay, sorry. So what's happened in America is that we have seen over from the 1950s to the 1960s, we saw the coming together of the arc of justice and the rule of law. It did not completely merge, but we have been making progress that this court has single-handedly tried to destroy. And so now we're seeing this diversion back to this divide between law and justice. And we're going to have some lower court judges basically dissent and impose their own, in essence, jury nullification against this illegitimate edict by this court. Now, I know that's a radical thing to say, but this is a radically out of control US Supreme Court that is decimating our rights. If the Republicans come for those judges to impeach them, fine. Then we will have more of a conversation about what's at stake, what this court is doing. But the bottom line is, if every issue you care about, if you do not join that with court reform, whether it's court expansion, term limits, jurisdictional changes, and the like, this court will rule for another 20 or 30 years in destruction, in decimation of our rights. every issue has to be joined with court reform. It affects all of us, all of our lives, and also our economic opportunity, like our rights and our economic opportunities, because this court has been aiding and abetting the corporate domination, the billionaire domination, including through that Citizens United decision that, again, John Roberts orchestrated after a second oral argument in order to unleash these billionaires for the last 16 years on our democracy, a tsunami of cash that is designed to drown out our voices. And we cannot let that stand.
Thank you. Andrew, bringing this back specifically to Ohio, what should voters here be paying attention to moving forward?
Ohio is a little bit of a different case when it comes to redistricting immediately. We are not likely to see sort of effort of this sort of rushed effort to change things. I mean, Ohio just had their primary, and because of the redistricting commission and its compromised decision on the districting that was made last year, we aren't likely to see a rush to redo that map so quickly. There have been a number of other changes, and I think one piece, we've been talking about redistricting, and there's this element that is communities being able to elect a candidate of their choosing. That is a huge protection of the Voting Rights Act. But another important piece, Lisa talked about the Shelby County decision that had required many of these laws to be pre-approved by DOJ, and in Shelby County, Justice Roberts did away with that. That was his first major sort of cut to the Voting Rights Act. But we also had a decision more recently in a case called Brnovich, which began to whittle away at other sorts of protections that had been in place to protect minority communities from laws that may have seemed to have, neutral applicability, but would affect particular communities more than others. And that was used for a while after DOJ preclearance was killed in Shelby County. That was a really important tool for communities to be able to fight back against things like voter ID, against restrictions on mail ballots or collection of ballots to bring in for communities that really relied on it, and communities that, maybe folks didn't have transportation to the polls. And so this was a key piece. And that was a really important thing in the case Brnovich that was coming out of Arizona. That was actually, much of that was targeting Native communities in the state of Arizona. And so that enabled all sorts of other discriminatory policies. Today, Calais, we're talking about the sort of broad structure of political districts and the ways that that can be discriminatory, but all sorts of other voting laws were formerly blocked by the Voting Rights Act and have been sort of discriminatory policies have been given free rein by the Roberts Court. And so there are changes that have been happening in Ohio election law that the Ohio government has been slowly chipping away at people's ability to vote easily and access the polls and make their voices heard. And so with that, all of the folks who are on this call are the people on the front lines. Those are the folks who are going to be your trusted sources of information to get you, those latest changes that are up to date, and talk through strategies of how to overcome some of the restrictions that the government has been putting in place. Things like requiring documentary proof of citizenship for certain voters, things like other sort of limitations on access to mail voting or early voting. And so really looking to the groups on this call and looking to the messaging that they're putting out as we're getting closer to election day and amplifying that messaging, because we are going to continue to see discriminatory policies. We're seeing it also from the federal level with executive orders coming down from the White House that, Common Cause is challenging. Many of our partners are challenging. We are going to be in court tomorrow with our co-plaintiffs, Black Voters Matter, and the NAACP to try to block that order. We're seeking an immediate block to that order from the president. So we're fighting in courts, but whatever they are putting up in our way, there are going to be organizing solutions and solutions that communities working together can push back against the barriers that they're putting in our way. And we've seen that happen historically. It is going to be a challenge, but the groups who are on this call are the folks who are going to be leading that fight. So really encourage people to keep up to date with what's happening, get involved in your community, get involved in your local chapter of the various groups that are on this call. Talk to our folks at Common Cause, Catherine, Mia, Kelly, they're amazing, and strategize with us of how we can get the message out to voters of what they need to do to make sure that their voice is heard on election day.
You mentioned, we have a moment here in Ohio before we take a look at redrawing our maps. We have until after the next census. And we did talk about a little bit about some of the proposed changes that are kind of in flux in the state legislature. But for those of us, right here today that need to make their decisions on, whether they're going to vote, how they will vote, what protections still exist under Ohio law or the Ohio Constitution. I know that, especially as a result of the radical nature of the Roberts Court, people have been increasingly looking to state constitutions for protections. So in Ohio, what here have we set up for ourselves?
You're on mute,
I'm
Andrew.
muted. Sorry. Um, you know, Ohio is one of those states that has protections against partisan gerrymandering. Part of what we've seen is that elected officials have disregarded that. They've disregarded rulings of the Ohio Supreme Court and just continued to push ahead. They've been unable to resist that pull of giving themselves an advantage. And we see again and again when you give elected officials the ability to choose their own voters rather than the voters choosing them, they are going to choose that every time. And so it is a protection that is already in Ohio law that folks need to continue voicing their support for. That is something that we want to see continue to be protected. I think there's also one thing that we're looking at nationwide, and we're already seeing attacks on it, but the protections of state voting rights acts. So those will never replace, and I want to be clear that the assault of the Roberts Court on the Voting Rights Act at the federal level is not something that can be fixed by state voting rights acts. There are protections that we are losing at the federal level that are irreplaceable, and Congress has to act to replace those. But there is still so much that can be done at the state level in terms of promoting state level voting rights acts. It's something that we have pursued in many states and continue to pursue across the country. Right now, we just got one passed in Maryland. We're working on one in Rhode Island, and that is something that folks can also sort of look to as a goal and something that they can push candidates and electeds to be supporting as they're, having those conversations and deciding where to place their vote.
Thank you. I want to open things up to the panel at large. For people that are watching tonight who may feel overwhelmed or discouraged by some of the things that our panelists have shared, what are some meaningful actions that ordinary people can take right now that would be impactful in this scenario?
I could jump in and just say your members of Congress need to be hearing that we need to reform this court, that this Roberts Court is out of control, that it is disrespecting the right to vote for Americans. That's, one thing to embrace that reform. We have to rebuke this court. We cannot accept this as just the status quo going forward. And I know that there's been some criticism in response to some of the immediate responses, like in Virginia and other places, as that state's effort to counter this was attacked by a Republican-dominated Supreme Court in that state. And Ohio has faced just incredible intransigence by Republican legislators against the Ohio Supreme Court, which ruled 5 times against the maps that the Republicans wanted to impose. Now Ohio has an agreement, in essence, on a bipartisan agreement on the maps right now, a 15-member congressional delegation with 5 Democratic representatives and 10 Republican representatives, even though Ohio voter registration is like 31% Democratic, 31% Republican, plus or minus 3%, and like 37% independent. And so those bipartisan maps preserve, seats, representation in Cincinnati, in Toledo, in Akron, in Columbus, and I'm forgetting one city. I'm so sorry. Please forgive me. Cleveland. How could I forget? Cleveland rocks. But the maps as they are already are out. They're better than what could have been, but they are not proportionate in any way, even though that's not a requirement. And I think we have to be thinking boldly about what it would mean to have a representative democracy versus this gerrymandered rigging like we've seen. And we know in Ohio that the Ohio legislature decided to put party labels on the Supreme Court elections in order to try to overcome the independent, nonpartisan rulings of the court trying to protect the right to vote. So this notion that the answer is vote harder, that is not the answer. Although we have to vote, we have to register to vote, we have to get more people registered to vote and protect the vote and have the vote count. If we have any hope to reform this, to restore this, we need a Congress that understands how this choosing your own the legislators choosing your own voters has meant that this Congress, this Republican-dominated Congress, and any Congress dominated by this billionaire class is not serving our interests. And we need bold reforms. So I guess that's what I would say. Do not give up. They want you to give up. Our foremothers and forefathers and the people who fought and risked their lives for their rights would not give up in the face of a Supreme Court decision or a ruling like this. We owe it to them and ourselves and our future to not give up and not give in, no matter what.
So I want to say ditto to, everything she said, and I want to go further. It is so important. It's very important that people vote. I mean, voters is in our name. So we understand the need to vote. And this year we have to, because we need to, in fact, as people have been saying, this midterm probably will be the last time that a cage can be put in place that may give other reforms or efforts that people are going to try to make legislatively, at the federal and state level even happen. So we must do that. And if you are in a state that can do that, right? I said earlier, abandon this notion of the colors on the map and see instead, healthcare. See instead quality air. See instead good schools in your community. See instead roads. Don't think about whether or not this person is a Republican or if they're red or blue. Think about, access for people to have more resources, higher wages. Those are things that we can all, agree and then let your vote align with that so that we can create a cage around this fascist takeover in this country. But I want to go a step further because I think that this country and living here, we think in terms of reform. And sometimes that's good for us to do, right? But what ends up happening is we're on this hamster wheel, right? We get the reforms that we want when someone's in power and when they're not. But because we're in such a gridlock, it's hard for that to happen. So even though you may have a progressive-minded Senate, you only got so many people and you can't get over the filibuster, and all these things choke away the visions that we may or may not have for a different country. So what do I mean by that? I believe we must start thinking about real structural changes. This country celebrates 250 years, and you may be hearing that everywhere you go, right? And there's some sense of pride about it. In fact, America has one of the oldest constitutions in the world. There has been an amendment process, but not a robust amendment process. And, but some would suggest that maybe it's time for us to begin to think about newness. For example, you think education is important? It is not a fundamental right in this Constitution. You think marriage is important? It's an interpreted right, not a prescribed right in this Constitution. You think that your body autonomy is important? Well, guess what? The Supreme Court only promised it to you through an interpretive case, which is what happened with the Roe v. Wade. It was not law. It was just an interpreted law by a court that we've seen has gone rogue. So how do we change and get off this hamster wheel? How do we do that? And so I think our communities have to start thinking about different type of democracy tools, because other countries in this world who have similar histories as America, they have things like proportional representation. And in this country, when you say that phrase, it becomes immediately demonized.
Yeah.
But actually, is it? Is it possibly a tool that we could begin to use to ensure that all the communities who live here actually have representation at every level of government? And so we've got to start reimagining radically, because be clear that when those enslaved people imagined a country where they were not enslaved, that was radical. It wasn't just morally correct, it was revolutionary. When those women met at Seneca Falls and made a decision that we are going to have the same constitutional right to vote, right, and get representation as men, that was radical, transformative. And so we've gotten a little bit lazy through the reform process. And we're not thinking and behaving like the way that our ancestors did, who radically reimagined. So how does faith work? How does faith and movement work? I think our ancestors give us an example of that too. It took 75 years between the Seneca Falls Convention and the erection of the 19th Amendment. So why am I saying that? I'm saying it because they knew that when a seed hits the ground and is planted, the ground immediately begins to shift and change ecologically in order for the plant to survive and thrive. But that knowledge that it's happening, they don't need to see the plant break ground in order to know that it's working. And so we've got to start to have that kind of same mindset, that our thoughts, because believe me, those who oppose what we want, this seed was planted a long time ago, and they nurtured that seed until it broke ground and this country could contain that level of retribution and hate. And so we've got to do the same thing. We've got to plant some good seed and not be afraid that the law or the country doesn't match it yet. For we need to know that when we plant our seed of righteousness and love and inclusiveness, that it is going to eventually break ground into the policies that we know that will be permanent, not those that may come and go, but that we're going to radically reimagine this country in a way that we will never, ever have to revisit this again. So, but you got to be neck deep. And I'll have a conversation with you later about what that means. But all I need for you to know today is you don't need for the plant to break ground for you to know that the magic is working. But you got to start, and you got to demand it, and you got to imagine a country free of, racism, right, and sexism and exclusion. You got to imagine it, really imagine it. And then imagine, what would that look like in this Constitution? Could we have fundamental rights that become Article 1, right? As opposed to an amendment process as an afterthought. Can we specifically describe the things that we need in our life? Can we put the care of the environment in our Constitution? Why must it always be a matter of legislation? Those are the kind of things that we must do, and we're being called to do in this moment in the same way that our ancestors did. So that's what I would say. Vote, vote, vote this year. Believe that your vote matters. Get some real good folks in so that we can contain this madness. But then get about building a new nation. We need you.
That was a message and a word. April, thank you so much for those gems. We also want to make sure that we hear directly from you. Our team has been collecting questions throughout the evening. So let's move to the audience Q&A. I'm going to do a quick time check. Laura, how much time do we have?
We have probably we can go as long as we want, as long as people want to stay, as long as our guests want to stay. I am inspired. Thank you. We've got probably 20 minutes.
Okay, great. Well, we have a solid list of questions, so we'll jump right in. Someone asked, can there be any action legally because of the unfair voting access, like uh, too few of the drop boxes in minority areas leading to long voting lines? They are thinking specifically of Georgia and Texas and they said, because I do see um, it coming to these newly districted southern states, or is that canceled out by the end of the pre-clearance?
I just want to jump in and say, first of all, April, every single word, thank you so much for sharing that inspiration. Second, there's ongoing litigation and litigation efforts that will be initiated in response to those efforts to limit the vote. And I'm sure Common Cause will be involved in that. Democracy Docket, Mark Elias, NAACP, ACLU, other groups that are the sponsors of this call. I'm sure to the extent that they have litigation capacity, they will be challenging those. The pre-clearance rules that John Roberts threw out in that Shelby County case, that vile decision by the Roberts Court that unleashed a whole array of voter suppression, what it did was it basically destroyed the ability of the U.S. Department of Justice to enforce rules that required states and localities to come to the Justice Department if they wanted to change the place of voting or how voting was occurring because of the mischief that these white dominated city councils and legislatures had engaged in. And so it applied to a number of states, predominantly southern states, and a few other jurisdictions. So there's no longer a pre-clearance requirement. However, and this is not entirely lemonade, but this Trump Justice Department would not, I'm sure, effectively enforce those rules if they were in place. And in fact, this Justice Department is actively trying to intimidate voters through some of its actions, through the taking up of ballots, the demanding of voter rolls, and the like. This Justice Department would not be suitable for entrusting with the responsibility of enforcing those provisions. I hope one day those provisions are returned. But in the meantime, there are provisions under state constitutions, state statutes, as well as federal statutes and federal constitutions, including the U.S. Constitution, which expressly provides that it is the states that set the terms for voting, not a presidential order or something written on a napkin and signed by a president as if it's law when it's not. So there will be robust litigation throughout coming up to this 2026 midterm and in the aftermath of it by litigating groups determined to defend people's voting rights, notwithstanding the fact that some of those key tools in the Voting Rights Act have now been decimated by the illegitimate rulings, in my opinion, of this captured Roberts Court.
This court has been blatantly infringing on, the rights of people of color because of political agenda. And so one of the questions harping on that note is, can a group of impacted citizens sue the Supreme Court for violating their rights and changing law passed by Congress?
Well, I have to say that is a bold move. I wish it were so. This goes to April's question of how do we contain an out of control Supreme Court under the current system. But I do think that there are things a Congress could do if there were a Congress that were empowered to investigate the corruption that has taken hold, that has engulfed some of the members of this court. If Congress could rebuke the usurpation of its proper prerogatives under the 14th and 15th Amendment to protect the right to vote that this court has wrongfully, inappropriately tried to take away from Congress through these actions, these hyper-partisan, really not judicially sound actions. They're not being fair judges. There are other measures that can be taken regarding other oversight and investigations. That would be the beginning of an effort where you could not actually adopt new measures until you had a new president who was supportive of the type of bold reforms that are necessary to create a thriving America in this next 250-year period, rather than just riding this rickety buggy. It's like riding this buggy on I-90 or I-95 from like 1791 while cars are zipping by. We are going to need a set of bold reforms to deal with and help us thrive in the 21st century in all the ways that April described. And that's going to require a Congress that is determined to protect our rights and really represent us, and a president willing to sign those into law.
It's actually a great follow-up. Someone asked, how can we put pressure on those representatives to reform the Supreme Court when it's really in their favor to be rigged in the way that it is?
I'll say one thing and then I'll pass it over to my fellow panelists. The fact is that Democrats have almost uniformly called for redistricting reform. There are bills that have been put up that would change this process, limit this ability to rig the system in these ways, and those efforts have been blocked by Republicans. It shouldn't be a party issue, but it is a party issue because the Republicans have refused almost every effort in state after state to have voting reform to protect for fair maps and in Congress. There are sometimes these little breakthroughs on bipartisan deal making to try to mitigate. We saw that in Wisconsin. I think we saw that in Ohio. But the fact is that when you look at this issue, it's not my fault. It's this way. The reality is it's Democrats who are supporting redistricting reform and Republicans who are almost always trying to block it, except for that little act of bravery next door in Indiana, where Trump then smacked back those Republicans who dared to stand up for not having an entirely jerry-rigged map in Indiana.
And I'll just flag, I saw Laura just dropped a couple things in the chat, a couple of petitions that Common Cause and Red, White, and Blue have organized. One of those from Common Cause is we are continuing to push. We have been fighting against partisan gerrymandering for decades now, and we brought that case to the Supreme Court because we believed it was wrong and unconstitutional, and the Supreme Court allowed it to go forward. And they have now supercharged that by pointing to it as the excuse that legislatures can use to break up minority communities around the country and dilute their voting power. And so that continues to be a solution that we are pursuing and pressuring Congress about. So that petition is in there. And to Lisa's point, it is something that Democrats have supported in the past. The Democrats have pushed through a bill to ban partisan gerrymandering, as well as make several other fixes to several of the sort of anti-voter policies that have been adopted by states around the country in the wake of Shelby County and Brnovich. And so this is something that they have supported, but we are going to need to see a change in the presidency and a change in who holds power in Congress in order for some of those measures to move forward. There's also the John Lewis Voting Rights Act, and there's a petition in there that was dropped in the chat to repair the wrongs of this court in the Shelby County decision and reinstitute a formula for DOJ to conduct that preclearance once again. As we pointed out, it's not going to be this Department of Justice, which has been, torn apart and sort of rebuilt to support whatever the Trump administration is pursuing. But having that tool again will be critically important. And so these petitions are a great way to make your voice heard with your members of Congress, and encourage folks to see those in the chat.
And I just want to add that, we oftentimes think of change in the large way. We look at federal legislation, we think about what's happening at the federal level for good reason. I'm from a community where most of our rights and protections had to come from the federal sector, right? But I do want to just say that change often happens from the ground up. And so what I don't want people organizing and protesting works. Black folk in this country didn't get the VRA because they voted that in, right? They protested to get that. They resisted. The accommodations laws were not challenged because we elected people that would undo it. People went to restaurants, they weren't welcomed. They rode on public transportation and sat in parts that they weren't supposed to, right? That's a part of protest. And so it is so very important that you see the connection between policy, litigation, and protest. And what is that? And protest doesn't just look like, just going in the street. Sometimes we do it in the chambers. We make sure that we are present at every committee meeting, whether it is at the city council, whether it's at the county commission, the board of education. My God, that's what they did. They started going to these meetings and raising hell, right? The Mothers of Liberty, I think I may have said it right, but they started by going to these board of education meetings and just raising their voices, right? One after one after one after one. So don't forget that that tool is available to you to change hearts and minds. I dare say that the Brown decision would have never happened had there not been a swell of a civil rights movement in this country. So I'm just encouraging us. Yes, let's sign the petitions. We got to do that. Yes, let's elect people, but let's get in these streets, right? And streets is just a poetic word for going to meetings too. Do the streets, but go to the meetings, right? And don't go just one, posse up. Make sure that you have a coordinated effort in your communities. Don't forget about city charters, right? Sometimes if people start, looking at city charters, dicing those things up, creating the local environment that you want your national environment to aspire to, what it does is it lets people see, you know what? We can have higher wages here if there's no preemption. Right? We can have different kind of protections here, and people can get comfortable with them enough to want to fight for it at a higher level. So all I'm saying is your voice, your time is like a drip of water. Yes, there are bombs that explode and break concrete, but a consistent drip over time will break concrete too. So be that drip today in your communities with your crew so that we can get the changes that we need.
As we begin wrapping up for tonight, I'd like to ask each of our panelists one final question, and then I'm going to hand things back over to Laura. That question is, what is the one thing that you want every Ohio voter to remember after tonight's conversation? And April, I'd like to start with you.
I don't have anything else. Be the drip. Like, seriously, be the drip and believe, because if you don't believe, it won't happen. And yes, there will be things around you that will challenge your belief in what you believe is possible and what you are dreaming for. But all that is an opportunity for you to go inward and have more conviction. When you get challenged and you become faint, right, in your well doing, just go in and have more conviction that you are right. And that is the kind of belief that will help us get a country that Dr. King had imagined, had seen the night before he was assassinated. Because be clear, y'all, we ain't there yet. Because if we were, we still wouldn't be fighting for the things that he was fighting for at that time. So we're going to get our beloved community, but you got to believe and you got to be the drip.
Andrew?
I mean, it is impossible to follow April, and I think Be the Drip is the line that I want folks to take away from this too. But I will just really emphasize, I think for me, when I think about this moment and showing up in this moment, being that agent of protest and disruption that April was talking about, I'm really thinking about doing it in community, because the people around you are going to inspire you. They are going to push you forward when it's not necessarily the thing that you want to be doing. But we had 300 people join in this call that was put together very quickly on a Tuesday night. And that is the sort of thing that inspires me. When I look at the day of Calais, I was talking to our folks on the ground in Florida, and they were in the state house debating these maps, got this horrible decision, and they were still fighting together. And that spirit of sort of joyful pushing the joy in the fight that I saw from them, that I saw from our folks in North Carolina who've been showing up at the state house to fight back post Calais there. It is something that I think really is going to be that fuel that can sustain us moving forward and is going to, make it more attractive for people to come into our tent and create that change that April's talking about. And it's that seed, and that seed can grow so quickly, and it may take a very long time to break through the ground, but by building that community, that's how you're going to be able to do it. So looking for those people who are near you, who want to join this fight with you, who you can convince to join this fight with you, that's what's going to be able to get us to move forward.
And I would just add, and I agree, April, such profound guidance and support for us all. I will just add that, hope is a decision. Hope is defiance. Hope is determination. We have to have faith that we can break through. They want to deny us that hope. They want us to feel like it's impossible, that it's inevitable. It is not inevitable. It is no way inevitable. The future has not been written. We can write that future, but only if we don't give up. Only if we do not give in. We may have to spell each other, pass that baton, share that weight, share that load to go far together. But we have an obligation to not give in and not give up. And the reality is, this is not a procedural fight. This is not a process fight. This is not a policy fight. This is a moral fight. And in a moral fight, you do not give up until you win. Until you win. We can be defeated, we can be blocked here and there, but as long as we do not give in, we will prevail. And we will put this moment in history in the context for what it was, this, despicable attack on our fundamental freedoms, on our equality and our communities. But we can only do that if we do not give in, if we continue to be those drops of water that accumulate, that aggregate, that are relentless in restoring and expanding our rights so that we can all thrive in America and on this planet. So, yeah, do not give in to cynicism. Do not give up. Stand together, join arms, get out into the streets, not just to vote, but to use your voice, to use your talents, your skills, to stand up and not give in and give up.
Wow. Before I turn things back over to Laura, I just want to take a moment to thank all of our phenomenal panelists. Thank you for your insight. Thank you for your wisdom. Thank you for your encouragement. I know I feel charged and energetic and ready, to go outside and take it to the streets to be the drip. And so I just wanted to, commend you all and thank you all so much for your time here tonight. And with that, I will turn things back over to Laura Mullen.
Hey, friends. As I said, I'm Laura Mullen. I'm the program director for the state of Ohio with Red, Wine, and Blue. I am ready to be the drip. And so what I'm going to do is I'm going to share screen. I've got a couple more things I want to share with you, and it is basically those QR codes and things that we wanted you to do, those calls to action. There is a QR code to ban partisan gerrymandering. You can hit that QR code. It takes you directly there. We also have, we want to tell Congress to pass the John Lewis Voting Rights Act. And then we also have, I have to make sure I can progress this forward. We have a couple of different activities if you want to continue the conversation, because we're not done talking about this. This is not going to go away. The conversation has been happening. It needs to continue to happen, and we need to continue to lift this up. There is a Fair Districts, Fair Democracy huddle tomorrow, a tech attacks on direct democracy. I wish I could use my mouth. Wednesday, 5/13 at 6 p.m. You can register. That's the number one QR code. And then you have Coffee with Common Cause on Thursday at 8:30 in the morning. Fantastic morning event. And then also there's an Ohio Voter Rights Coalition call on Friday the 15th. You can hit that QR code as well to register. And then we have a couple of different fun things that are brand spanking new, and Red Wine and Blue always does things a little bit differently. We are social banking. We want to break the algorithm on social media. We hit Facebook and Instagram and we lift up posts that share correct information. We do not share myths and disinformation, and we lift that information up to your friends and to your family on social media. And so if you would like to join our social banks about voting rights and about protecting democracy, you can hit those QR codes as well. I'm going to stop sharing screen. Or actually, I have one more screen. I want to thank, last thing I want to share. Saturday, May 16th, there is going to be a gathering in Alabama, and folks are going to be gathering together to protest, to work together. And if you in Ohio want to put together a protest in support in community with Alabama and their voting rights fight, the voting rights work that needs to be done, here are some actions that you can take. You can declare that you are attending a rally. You can post on social media that you are doing things. You can amplify what you are doing. We would love for you to be involved in this. We're going to be sending out follow-up information in our follow-up email from this event. We've been recording. We're going to share links with you. This is a moment and this is a movement, and we would love for you to stay with us in it. We'd like to thank all of our partners, all these folks on the board, on the panel who joined us tonight. I am inspired and I am incredibly happy to be in community with our friends across Ohio. And so with that, good night and thank you so much for being with us. Thank you, Ainsley. You did an amazing job. Thank